The Honorable Supreme Court of the State of New Mexico.
Please be seated. Good morning, Council. We're here this morning on S-1-SC-39343, State of New Mexico versus Antonio M. Can I have entries of appearance, please?
Carol Franklin, on behalf of the petitioner of the State of New Mexico.
Good morning, Nicholas Hart on behalf of Antonio.
All right, Ms. Francolini, I see that you have reserved 24 minutes for your main presentation and 6 minutes for rebuttal. Is that correct?
That's correct.
All right, you can go ahead and proceed.
May it please the court. This case presents the court with an opportunity to clarify whether federal due process protections apply under Manson versus Brathwaite when a prosecutor elicits a first-time in-court identification by allegedly suggestive means. The Court of Appeals did apply Manson in this case and found that 3 in-court identifications at Antonio's adjudicatory hearing were unduly suggestive and that they warranted reversal under a plain error standard. Now, even if Manson does govern in this case, the Court of Appeals analysis was flawed in 2 respects. First was because the child's identity wasn't at issue and was essentially conceded throughout the hearing, at least for purposes of these 3 identifications. There was no plain error in this case. And second, because under Manson, the court did not engage in the 5-factor test that is required for assessing reliability. And under the facts of this case, when we look at those 5 factors, the identifications were reliable. So I'd like to first discuss the Court of Appeals analysis, starting with the plain error analysis and moving on to the court's Manson analysis, which then kind of frames the second portion of my argument, which is the question of whether Manson is the most appropriate analysis in cases like this one. So this case was somewhat unique in that there was a very high bar for reversal here, and that's for 2 reasons. The first is that the court applied Manson, and as this court recognized just last year in State versus Martinez, Manson sets a high bar for exclusion of identification evidence. The Manson test is typically used to determine whether out-of-court identifications arranged by police can be admitted at trial without violating federal due process. So under Manson, there are 2 prongs, and both have to be satisfied to warrant either suppression of identification evidence or, in this case, reversal after the fact. The first thing a court looks at is suggestiveness, and a court asks whether...
I don't want to distract from your outline. and maybe it will help me in my analysis. But isn't the first question whether identification was an issue? Meaning the defense seems to assert not that the defendant wasn't there, but they didn't participate in what caused the murder, the felony murder or the conspiracy. Isn't that the first question?
That's correct, and that goes
Before
into,
we get in, and then continue with your outline, but
yes, of course.
for purposes of our analysis, is that the first question? Or
I would agree that it is, Your Honor, because it goes to the plain error standard. And the first question, some courts have said that even if Manson is the correct analysis, the federal due process protections aren't implicated where identity isn't at issue to begin with.
So you don't reach plain error in that instance if federal due process isn't an issue.
Right, and if it is, if the court were to disagree in this case, it's still under the plain error analysis. It doesn't, we don't get to plain error under
So
the
you
facts
don't-
of this case.
So part of your first part is whether we would even apply Manson at all, because this is not this is not police. This is not a pretrial identification by police. And the Perry case clearly states, in my mind, Perry's challenge, the court found, failed at step 1 for Blandon's identification did not result from unnecessarily suggestive procedure employed by the police.
Correct.
So why would we, I just don't even understand why we would apply Manson, and if you think we should.
Well, the state is really just seeking clarification because there does not appear to be consensus in New Mexico law as to whether Manson should apply in these cases. Courts have taken several different approaches. This court most recently, I believe in Ramirez, it was sort of a hybrid approach where the court found because the alleged suggestiveness for the in-court identification wasn't by the prosecution, Manson didn't actually apply. And then it looked at Perry to see whether these trial safeguards are in place that give the defendant the opportunity to challenge the in-court identification. So the state's position is that in these cases, based on New Mexico law, Manson does not appear to be the analysis that would apply. And
we would apply, I mean, we're not looking at the state constitution, so we do have to look at US Supreme Court cases. And throughout Perry, it's talking about police and pretrial identification. The distinction being that during trial, they have safeguards in place. They have the right to counsel. They have the right to cross-examination. They can present experts on the issue. They can ask the judge to suppress it under the rules of evidence because it's more prejudicial than probative. So I want you to talk about that distinction that's in our federal case law that governs the 14th Amendment.
of course, and Manson was really formulated and designed to address out-of-court identifications arranged by police. And the distinction between those and first-time in-court identifications by prosecutors is very important because, as Justice Zamora was saying, in court, when an identification happens for the first time, the defendant has many tools at his disposal to challenge the reliability of the identification. And the only due process protection when we're talking about identification evidence is just that it needs to be reliable. So in court, where an identification is happening in real time and it's not tied to a pretrial out-of-court identification, the defendant can file a motion to suppress before the fact. He can object as the identification is happening if he doesn't like the procedures that are being used. He can cross-examine the witness and use any number of approaches to try and to establish that the identification wasn't reliable. He can argue in closing that the identification wasn't reliable.
Can he ask for a lineup in court?
He could. I don't believe there's a New Mexico case that says a defendant has a right to that, but I believe that would be looked at on a case-by-case basis under the facts of the case. But he does have a right to do that.
Can I ask you
Yes, of course.
two things? Because I want to redirect you to the beginning a little bit here. But first, the first question I have, isn't the focus here supposed to be the impact on the witness as opposed to the jury?
Yes, that's correct.
And isn't that an error in the Court of Appeals analysis? They focus on the impact on the jury, not the impact on the witness.
Right, and in this case, that error is magnified because there were all these other things that were said by defense counsel throughout the trial that said, hey, please believe these identifications are
So
correct.
that's going to take me back to the beginning.
Okay,
I don't think that you've had an opportunity yet to actually answer Justice Thompson's question, which is, was identity at issue in this case?
it was not, Your Honor. Not only were these identifications not objected to, they were not challenged on cross-examination of any of these three witnesses. They were not challenged in closing argument. And in fact, in defense counsel's opening statement, he essentially told the jury, this is our theory of the case. This is Antonio. He did go to the park on this particular date with these three kids who are going to testify that he did go to the park with them. Defense essentially freely admitted that Antonio did go to the park, but because he was charged with felony murder, which required the state to show that he somehow encouraged or helped with this robbery plan, the defense's theory was he had no idea that a robbery was going to happen when he went to the park. And we know that because these witnesses testified that he was totally silent on the ride to the park, so that shows that he didn't have a plan. And then he ran back to the car 5 to 10 minutes later, completely in a panic. And we know from that evidence that, again, he had no idea this was
And
going
the
to happen.
state's theory wasn't that Antonio M. was the shooter.
No, it was undisputed that it was another juvenile who was the shooter. So the state's theory was just that Antonio helped or encouraged or planned in some way.
So then my question from that, if we agree with you that identity is not at issue, do we need to go any further?
No.
But it would not provide the clarity that you seek on in-court identification.
That's true. I think the court could reach the issue of whether Manson is the appropriate analysis if it were triggered in this case, if the court wishes to. But if identity is not at issue, that ends the analysis, either because due process protections aren't triggered in the first instance, or because regardless of how Manson is applied, there just isn't any plain error. Because the defense relied on these identifications and kind of endorsed their accuracy. So there's no way under a plain error standard that they infected the jury's deliberations or created grave doubts about the verdict.
So if we go into the Manson discussion, recognize the quote that's found in Perry, that Perry had nothing to do with in-court identification. It's out-of-court identification, law enforcement. I think there's an argument to be made that the prosecution is part of law enforcement.
I agree.
But aren't there federal cases post-Perry that employ the Manson factors?
Two cases like this one?
Mhm.
Yes, there are.
Can you talk to us about those?
It's essentially a circuit split, and those courts really say exactly what Your Honor just mentioned, that it's state action, not just law enforcement.
And Perry uses the language of state action.
It
correct?
does, and that was something that the state, upon full briefing in this court, kind of dove into a little deeper and realized that prosecutors are likely state actors, especially if we look at all these other cases from other jurisdictions. But even so, there's another distinction that's very important. Even if prosecutors are state actors under Manson, Manson is geared toward these pretrial, out-of-court identifications where there are just no safeguards in place, where somebody is, hauled down to a police station. They don't have an attorney, an officer.
Just to show up.
Exactly. There's one case where the defendant, they showed a spotlight on him and he was the only person there. So that's what Manson is designed to address. But again, when we have these identifications that are happening in real time in court, those concerns just aren't present. And there is
But you're not, are you saying then that 14th Amendment due process protections do not apply to a first-time in-court identification
I would say that they don't.
at all?
Not in this case.
Well, I'm not saying, I'm not.
But I mean,
speaking to this case.
what triggers once the in-court identification comes in is the Sixth Amendment and their right to counsel. But in any case, detention hearings, anything, there's always that reliability requirement in every single case.
Exactly.
But what would we do if, take the extreme example? I mean, I'm not thrilled with what happened in this case, subject to the other procedural safeguards, but just the fact of how, pull down your mask. But say you have a prosecutor who brings in a neon sign and says, this is the guy who did it. and holds it above the defendant's head, what do we do with that if there's no constitutional right?
Right, and that's the position that the state is in, is that the state doesn't want this court to create any kind of standard that would sort of give prosecutors free rein to do
So,
whatever they want.
Would the rules of evidence apply to that hypothetical? Would there be an argument that that evidence is more prejudicial than probative or not reliable under the due process clause?
I would agree that there is an argument, and there's always opportunities to kind of shut down that kind of procedure as it's happening. And
You
that
can't
does-
unring the bell if the
Right, and that
prosecutor
does-
walks over and says,
That's true.
Michael Vigil, is this the guy you saw?
That's true.
You can't unring that bell. So what do we do with that? Because it's not going to be evidentiary. It's not going to be cured through a curative instruction. It's either going to be a mistrial or something else. So what's the something else, and what do we do with the prosecutor who engages in that behavior? Because I don't want anything that we write here to suggest that that would be a very low bar.
Right, I agree with you, Your Honor. And there's one opinion, it's an unpublished Court of Appeals opinion that was written by then Judge Vargas, State versus Martinez. And the approach that Justice Vargas took in that case was, even if we just presume that all in-court identifications first time are suggestive and we just move on, we really focus on reliability and we focus on the fact that those other constitutional safeguards were available to the defendant. In this case, the Court of Appeals just kind of disregarded the other safeguards and just said that Antonio had no opportunity to counteract the taint of these identifications. And that's incorrect, because the standard is not whether the defendant used the safeguards, it's whether they were made available to him as part of due process. if it
Using
doesn't
my
apply.
scenario, because I'm not sure in the, Jacques type of scenario that the procedural safeguards, they might not prevail there. But with that prosecutor, would Bright be an avenue for recourse for a defendant that would rise to the level of prosecutorial misconduct?
I think that's certainly an option. There's also claims to be made after the fact for ineffective assistance of counsel if a defense attorney
Doesn't
just kind of
object.
sits by and doesn't do anything. But this case really highlights why Manson, one, shouldn't apply under these circumstances, and two, certainly shouldn't warrant reversal where identity is not at issue. There's no objection. There's no challenge made to the identifications. And then after the fact, this test that was designed for out-of-court police identifications is applied to reverse and get a new adjudicatory hearing. So if Manson does apply in this case, as I mentioned in my opening, the Court of Appeals didn't reach the 5-factor reliability test. It just kind of breezed by it and said, because these identifications were suggestive, they also were unreliable. So one thing that the state would ask of this court, if this court does hold that Manson applies in these cases, is to really clarify that a court has to go through both steps. It has to look at suggestiveness, and even if suggestiveness is found, a court still has to move on to reliability, and it has to look at each one of those 5 factors and weigh them.
So what do we do? How would we advise the trial? If Manson applies, how would we advise the trial courts to address the issue when, like in this case, there was no objection? Would the court, how does that play out? And would the court sua sponte raise it if there was a concern? Is it the court's obligation to sua sponte?
That's
Because
a
in
good,
this case, they didn't object.
right, and that's a good question. I wouldn't say it's the court's obligation, but a court could absolutely sua sponte raise it. And I think if it's very clear to a court that what's happening is so incredibly suggestive under the circumstances that it needs to be shut down, that a court would.
But aren't the Manson factors, the reliability factors, really the availability of those things, whether they're used or not? Because then your argument becomes ineffective assistance of counsel if they're not used, as opposed to something that is procedurally deficient.
So the Manson reliability factors look at the specific facts of the case and then weigh the witness's opportunity to observe the defendant, the degree of attention paid.
Length of time, and all of those
Right.
things will be in the record. Whether there's an objection or
Hopefully.
not is ultimately the decision of defense counsel. And so it's the availability, I think, of objection as opposed to the fact of an objection.
I agree, and it's.
Because I want to keep district courts from sua sponte doing anything on the objection ground.
I agree, and it's sort of like the right to confrontation. You get the opportunity to cross-examine. As long as you have a meaningful opportunity to cross-examine, whether or not you did or your counsel did, that's not the question. But here, the Court of Appeals really just kind of found,
Just jumped past
well, even
all of
if he had used these protections, it wouldn't have worked. Which under the circumstances, there's really just no support for that kind of reasoning.
If identity is not an issue, let me back up. Every in-court identification is suggestive to the witness and to the jury, both. Would you agree with that?
That's what the New Mexico cases say, yes, Your Honor.
So suggestiveness is not the issue. The issue is whether or not, under a plain error, now, if there's no issue as to identity, under a plain error analysis, you don't even get to these other factors because if there's because it's not an issue in the case, the fact that there was an identification made, that suggestive identification, has no bearing on any issue factually or legally in the case, correct?
That's correct. And
In the facts of this case, we don't even get, if we agree that the identification was not an issue at trial, we didn't even get to these other factors or discuss these other issues, right?
right, that's the state's position. And part of the reason for that is that at the first Manson prong, we have to ask whether the identification was so suggestive as to create irreparable misidentification. And irreparable implies there's something to be repaired. And if identification is not at issue, if there's no identity at issue, there's nothing to repair. There's no irreparable misidentification. So yes, if
And
it's not an issue,
isn't one of the burdens the state has is to prove identity in the case,
that's correct.
right?
Does that ergo make identity a question? Put it at issue?
Well, the state recognizes that identity is almost always an issue in a criminal case, but it can be at issue in different senses. And here, there was obviously a question about, was Antonio one of the three people who actually participated in these crimes? But as far as whether he was one of the three people who went to the park that night, just as the three witnesses testified he did,
Just placing him at the park.
yeah, there was no issue. And there was other evidence that tied him to the actual shooting that was independent of these three witnesses saying he went to the park
Does
that
New
night.
Mexico have case law that discusses that identity can be at issue for various different things? I know I've reviewed Connecticut case law that suggests that. Have we said that you're aware of? I couldn't find anything, but that doesn't mean my search was perfect.
There is one case,
And I can ask you the question a different way.
no, that's,
Should this court say that out loud, that identity can be at issue for certain things and not others?
I think that kind of clarification would be very helpful because the Court of Appeals in this case said at one point in its opinion that identity was a central issue in the case, which is not incorrect because identity as the shooter or a participant in the robbery was certainly at issue. But the identity as someone who went to the park was never, it was acquiesced to by the defense the whole time. There is one case, State versus Leyba, which is 2012 NMSC 037. The issue wasn't introduction of identification evidence in that case, but this court found that the defendant's identity wasn't at issue where he admitted to committing a homicide, but his theory was that he acted in self-defense. And I believe it was
So it gets close without an overt statement.
right. And I think it dealt with introduction of his booking photo, and the state said, we want to prove his identity. And this court said, you didn't need to prove his identity. It wasn't an issue. So you can't bring in the booking photo because it's character evidence. So even if we go through, I would like to discuss the 5 reliability factors, because I think even if this court finds Manson applies, it's really important to look at reliability, which the Court of Appeals did not. The Court of Appeals and the defense have put forth this idea, both in the opinion and briefing, that these kids had extremely limited interactions with Antonio, which is just not supported by the record. 2 of these witnesses actually knew him before this night, before August 4th, 2020. And one of them had known him for up to a year through acquaintances, the other, I believe, for several months. So their opportunity to observe him, on top of the fact that they already knew him, they were in the car with him for 3 separate car rides. I think each was at least 6 minutes based on the record. They're speaking with him during that time. They're observing his demeanor. They recounted specific statements that he made during that time. They could tell whether he was nervous or calm or quiet or talkative. And that kind of goes into the degree of attention paid, which is the second reliability factor, because the testimony really indicates they were paying very close attention. They had very ample opportunity to make observations about him. The third factor is the accuracy of their earlier descriptions of the defendant. We don't exactly have that in this case, but all 3 of their descriptions, they were a little sparse, but they did focus on this very distinct characteristic of his hair, his hairstyle and dreadlocks with blonde at the ends. They all matched one another, so I think that factor weighs in favor of reliability as well. The fourth factor, which is the witness's certainty about the identification, none of these kids expressed any doubt that Antonio was the person that they had testified about. And the time that elapsed between the crime and the identification, which is the final factor, in this case, it was 6 months between the night of the shooting and the adjudicatory hearing, which in some cases could be a large passage of time. But considering that these kids knew Antonio and that they had spent essentially this whole evening with him, in this case, I think that factor weighs in favor of reliability as well. I see that my time is up, so
We'll see you again in 30 minutes.
yes.
Mr. Hart.
Thank you. Good morning, and may it please the court. Since 1970, the federal courts have recognized that coercive in-court identification techniques can violate a defendant's right to due process. While there is a bit of a change here during oral argument, what the state is essentially asking is for the ability to engage in coercive in-court identification techniques, because the procedural safeguards that are found in a trial eliminate any due process concern. But as the United States Supreme Court has recognized in United States versus Wade, is that even though cross-examination is a precious safeguard to a fair trial, it cannot be viewed as an absolute assurance of reliability.
If a defendant is not contesting that he is the accused, that the person that all the witnesses are talking about, and he says he's got an alibi defense or something like that, how can an in-court identification possibly impact the result of the trial?
I agree with you, Justice Vigil, except that's not what happened in this case.
Well, I understand, but you're making a blanket statement that coercive identification procedures violate due process.
But
that's not true in all cases.
But they would violate due process unless there's some other indicia of reliability. That's what the federal courts have said.
Well, reliability can be a concession that it's me, either explicit or implicit, and how the defense is presented.
That's correct, Your Honor, and I agree with that, except that's not what happened in this case.
Okay.
While Justice Thompson is correct that the testimony was that Antonio M. was at the park, that's not the identification testimony that's at issue. That's not the identification issue in this case. The identification issue is that they testified who he was with, that he was with them after, his demeanor and statements. Now, all of that is the circumstantial evidence that the state relied upon to say Antonio M. was one of the 3 people.
But it's also the testimony that the defense relied on for its defense. Look at his demeanor. He was scared. He was shocked by the events that he had seen, etc. And that's pervasive through the entire trial from opening through closing. So I'm not sure I agree with you that that was somehow different than simply the identity that he was at the park.
I disagree, Your Honor, because
I would expect you to, by the way.
the arguments made by counsel and the analysis that is starting to form is whether there was essentially ineffective assistance to counsel, starting to look at the strategic decisions that counsel made in both his opening statement, his closing argument, and the cross-examination that he engaged in. But if we look at the trial as a whole and the record in its totality, whether or not Antonio M. was the person, one of the three individuals at the car that engaged at the robbery, is the key issue of this trial. And the way that the state proved that up, the only evidence that they have of that, because the one eyewitness to it could not identify him, the other individual who was around the park, who was able to see two other children that night but could not identify Antonio M. as one of them either. The way that they did that was the circumstantial evidence from these identification witnesses.
And his own statements. I mean, his admissions to the witnesses as well
Right, but
supported their identification.
absolutely, Justice Zamora, but all of that still ties into the identification, right? If Antonio M. is not the person that they are talking about, none of that testimony is probative. And I don't think that we could separate the testimony that the state relies on as the circumstantial evidence that he participated in this crime once they engage in this identification and they give the indication to the witness of who they want to be identified as the person that was in the vehicle with them that night, the person who made those statements, the person who engaged in that demeanor, and the person who took those
So you'd be okay
actions.
if this case simply involved what I call the collateral witnesses saying he went to the park?
I think that if this case only said he went to the park
With these
with these
guys.
people,
Yeah.
then that's a different identity issue and a different manner in which the case would have been presented, where
But if the defense's opening begins with, yeah, he was there, he didn't know this was going to go down, I'm not sure these other things are fairly at issue in terms of creating an overly suggestive identification.
But the defense's opening wasn't yes, he was there, but these things, he didn't know they were going to go down. It was that he did not participate in them.
But he doesn't, but they're not contesting that he was there. And I kind of get why the defense attorney, he's like, I'm not gonna, we're not gonna tell you he wasn't there. We want you to focus on the fact that he didn't do it. He wasn't involved. It wasn't his idea. And to me, those are two separate issues.
But I agree, Justice Moore, but the identity issue was not, was he there? Was he this individual who engaged in the robbery? And
But
the
that's
only
separating
evidence,
conduct versus identity.
I don't agree, Your Honor, because the conduct is undisputed, what the three individuals did as part of that robbery. And the only issue in this trial is one of the two people that outside of the vehicle, Antonio M. And the only evidence that the state has to prove that up is the testimony of these three identity witnesses who say, through who they use the circumstantial evidence to say, his demeanor, what he said, that he was with these individuals before and after, that they were at this party together. So the question becomes in this trial is that person Antonio M? And Antonio, the child respondent in this case, was deprived of due process and his ability to challenge that once the prosecutor engaged in the techniques that they did here.
Except in the opening, and this is just my summary of it, defense counsel doesn't contest his whereabouts at all. And he focuses on whether he helped, encouraged, or caused, which is exactly the testimony about his demeanor. So they're not even contesting his demeanor because that's the crux of the defense. His demeanor is, oh my God, freaking out. I didn't know this wasn't going to happen. I had nothing to do with it. So that's what the defense is relying on ultimately for primary defense of Antonio M. if that's the case, I don't see how, even if I were to agree, if I agree with you that the demeanor type of testimony is identification testimony. Defense fully embraced that as their trial strategy. So I'm still not sure, I'm not convinced that it was an issue.
I disagree that the trial strategy was merely demeanor. I think that
I
probing
didn't say
it,
merely, that it was a key factor to the trial strategy, which is he was there, but he had no idea this was going to happen. Look, he was terrified. He was, beside himself, suggesting he didn't know what was going to happen and he was surprised. That puts his demeanor squarely at issue.
I
And
understand.
conceded.
I understand your point, Your Honor, but I think that when we're looking at the opening statement versus the summation, and I think that looking at strategic decisions counsel makes based on the evidence as presented in the trial, and I agree there are issues in this case of should there have been an objection, could a lot of this have been avoided if it was dealt with in the way we believe it should have been dealt with, but that's not the record that we're here with. The record that we're here with is that, yes, counsel did make arguments based on the evidence that was presented at the trial, but the point of the Court of Appeals
You made it
decision.
before the evidence was presented.
I understand.
You made those statements before any evidence was presented.
I understand, Justice Moore, but just like with many other evidentiary decisions that we look into, both with 404B and other instances, you're not required to ask for curative instructions. You're not required to do all these things because the defense does have the ability to make a strategic decision to argue the evidence as before the jury in order to get the best result for their client. And to say that identity was not an issue at all in the trial, when there are statements in the summation that eyewitness identification is an issue, challenging the eyewitness identification testimony, whether or not it's the most persuasive issue, I think is a separate analysis of whether it was an issue at the trial and whether the procedural safeguards that exist are enough to eliminate any type of due process concern. And that's what the Court of Appeals determined here, is that the procedural safeguards would not have been enough to overcome the due process concern that is created by the type of identification in this case. And just to reiterate, the standard is not, was identity the only issue or was identity the key issue in it, but did the defense make identity an issue? And we're looking at some of this is,
So
sure.
practically, in this case, can we take EM, the witness EM, you familiar with that witness?
Yes.
Okay. So you're writing the rule. Let's say you prevail. You're writing the rule. And as I understand it, it's okay if EM says, I gave defendant a ride. He had this hair, long hair, and describes the defendant. But what was it about EM's testimony then that implicates this due process concern? I'm trying to understand specifically. Was it, I don't know what else about EM's testimony that requires these safeguards. Because all they were doing was putting the defendant at the park. If it was someone driving by and they're walking down the street, they're just putting them at the location. What was it about EM's testimony, for example?
So, Your Honor, I think the portions about EM's testimony and the other two identification witnesses that show that these are not conduct witnesses, these are identification witnesses, is that their testimony is used to say that EM is the individual that participated in the robbery. I'm sorry, that Antonio is the individual.
So the element that really you're focused on isn't what the fact that he was there, it's whether he helped out, whether he aided in the commission of this crime. You're saying that their testimony identified him as someone who aided and assisted in the crime,
That's
not just that he
correct.
was there. Okay. So, because, if you have a jury instruction, one of the elements is it the defendant? And the next one is, not only is it the defendant, did the defendant aid and help in committing this crime? So yours is more the latter. It's not that he was there, it's just that he aided.
That's correct, Your Honor. And the
Okay.
state referenced, how defense counsel said this is Antonio M, this is Antonio Santiago M. And the reality of these cases is that by the time we get to trial, there are many layers to ensure identity, that the person who is sitting there is the named party, right? It has the same name as the individual. So the key question, it has the same name as the individual on the caption, right? So the fact that defense counsel is referring to the child as Antonio throughout it and isn't standing up and saying he's not Antonio M.
So getting back to Justice Zamora's question, can you point to what testimony of EM you think shows that he aided in the actual crime? What testimony should I be looking at to say, oh yeah, that's the guy who aided in the crime?
So EM testifies both about discussions prior to going to the park between individuals, that they were there to hit a lick or to carry out a robbery. EM also testifies about the demeanor and discussions afterwards, including Antonio's demeanor at the person he says is Antonio's demeanor at a party, right? And that testimony is used specifically to say Antonio is one of the three individuals that engaged in the robbery. It's the same thing for the other two witnesses, one of whom was also in the vehicle. They're talking about his demeanor afterwards, his statements afterwards, and the third individual who's talking about interacting with him at a party. That's putting him.
No, go ahead.
That's just identifying the person, and that's the person that said it.
Because
That's what was, it's not that's the person that committed the crime. So in any circumstance in which you have a witness, third party completely removed, that's a person and that's what they said. You're going to build in these safeguards at a trial?
Well, the safeguard isn't related to that testimony, Your Honor. The safeguard is related to the actual identification procedure.
But
The
you have a problem
testimony
with the
both
testimony.
identifies actions and conduct, demeanor, etc., of the accused, and it also identifies the accused. So then there's a subsequent specific identification that's already been identified by that testimony. So where's the harm?
So the harm, Your Honor, is that.
Where's the plain error harm?
So the plain error is, can any procedural safeguard overcome what occurred with that identification, right? The whole purpose of the testimony, and this is the only testimony that the state has in this case related to Antonio's participation, is that the whole purpose of that testimony is that Antonio M. was the individual who participated in the robbery. And the harm is that once the identification procedure happens, where the state points out the individual, pre-identifies the individual, does everything for the witness before asking the witness to identify the individual, does that call into question the validity of the verdict? And this is not an instance like in Leyba, where the individual said, yes, I committed the offense, but I have a justifiable reason to do so. That's a separate issue. Identity, whether he committed, as long as there's a question of whether the defendant committed the offense, there's a question of identity that remains in any case.
So assume with us, assume that we agree with you that identity is at issue. What does the law tell us to do from there?
In pretrial or in the posture that we are?
Case at hand.
So in the case at hand, what the law says is exactly what the Court of Appeals did, is that their analysis has to be done to determine, was the identification unnecessarily suggestive, which I don't believe there is any legitimate dispute in this case that the identification procedure was unnecessarily suggestive.
What would you suggest to make it not unnecessarily suggestive?
The prosecutor could have simply asked, do you see Antonio M. in this courtroom? And we have all lived with masks for 2 years.
Then the argument is, and I don't mean to interrupt you, but then the argument is that that's a flawed identification because he had a mask on.
Except this court has rejected that argument. That is not a flawed identification. The courts.
That's the argument to the jury.
But the COVID order actually allowed the witnesses to take the mask off. That was cited in the briefs, just for identity purposes.
Right, but the question is it necessary? Right, just because it's authorized by the COVID order doesn't mean that it's necessary.
And I'm not just, I mean, I think this could have gone down differently. I guess I'm wondering, if to follow up on Justice Bacon's questions, what you want us to apply the law that the Court of Appeals did to this in-court identification?
What is the law that controls our analysis if we agree that identity was at issue?
Right, so it's the Manson standard, Your Honor,
The
which is
Court of
first.
Appeals did not engage in all of the Manson factors.
I disagree, Your Honor. They did not say, in considering factor number one, this is what we determined. But this has gone over in page 11 of our reply brief, which is the Court of Appeals does have statements of findings related to these factors, right? The in-court identifications were unreliable because the identification witnesses had limited opportunity and attention to identify Antonio M. as being at the park, that there were no previous identifications to demonstrate consistency or reliability, that other witnesses who were present there could not identify Antonio M. as having participated in the crime, and in fact, identified others as having carried out the robbery. This is looking.
They don't talk about certainty or the doubtful nature of the testimony. They don't pay any attention to the degree of attention paid.
I don't think that the law requires that they state and overcome every single one of the 5 factors. The law requires a totality of the circumstances analysis. And the fact that they are specifically discussing the findings that they made determining related to the reliability of the testimony, including the way I counted 3 of the 5 factors.
On the reliability of testimony, are you suggesting it's reliable that he committed the crime, or it's reliable that that is the person?
I don't, again, Justice Thompson, I don't see that as different, right? Like the whole point of the testimony is that this is the person that the witness is talking about.
That they otherwise can identify that person.
Right.
Not that that person, there's other reliable evidence with regard to the crime.
That's correct.
Okay.
The reliability is about the identification itself.
Okay.
So what other indicia of reliability are present that can overcome the suggestive nature of the identification?
Did the Court of Appeals err in focusing on the effect of the identification on the jury as opposed to the witness?
I don't think that they did, because I think under Manson, the question is the effect on the witness, but under the plain error standard, the question becomes the effect on the jury, right? Was the procedures, was the evidence and the wrong admission, the incorrect admission, sufficient, so minimal that the jury still could have overcome the prejudice from it, right? So there are those 2 factors. I agree, Justice Bacon, under Manson, the question is the witness,
Okay.
right? Did the identification overcome the witness's ability to be reliable? Plain error certainly looks towards the effect on the jury, the effect on the decision maker. I think, Your Honor, too, what's important to point out is that the cases that the state relies upon, and Perry, which has come up several times in this argument, is not the case that we're dealing with here. This is not a case about the accuracy of eyewitness identifications or the reliability generally of eyewitness identifications, which is what is at issue in Perry, Ramirez, Martinez, all the federal cases that we've discussed. The issue is whether the conduct engaged in by the prosecutor themselves is unnecessarily suggestive in this case. So in Perry, the issue was that there was no state conduct, that there were environmental factors that the defendant was challenging to say that the identification was unreliable. That just because the defendant who was in the courtyard, in the parking lot of the building, was the only African-American, was the only person next to law enforcement, appeared to possibly be a suspect, that's not law enforcement's fault when someone looks out a window. The same thing is true in Ramirez in this case. The media coverage, the challenge, the eyewitness testimony was that the media coverage meant that it was unreliable. But the media coverage is not state action and not law enforcement action. And the same thing in Martinez, from Justice Vargas's opinion in the Court of Appeals. The issue in that is the way the defendant shows up in a preliminary hearing in an orange jumpsuit, in handcuffs and leg irons, something that leads to a suggestive identification.
I'm going to ask you the same question I asked opposing counsel. Since you're saying what would the trial court do in this situation where, as far as, I think there's a reasonable argument that they did not think identity was an issue based on the opening statement. How would they have addressed this suggestiveness issue if there was not an objection?
Well,
How would you write an opinion that instructs our trial courts?
I think that we all could have avoided this situation, and if I was doing this trial, I would object, and I would ask to approach, and I would move for a trial.
We'd wave our magic wand.
As many of us probably would have. But the situation that we're in the post-trial circumstance applies the Manson factors. When we're in pre-trial identifications, we have a mechanism, through a motion, through asking the court to review
But this
things.
stuff happens on the fly. This stuff just happens without all the time. A lot of times courtrooms are empty because they're low profile cases. There's not a lot of people in the courtroom. And obviously there's only 2 people sitting at defense counsel tables. So I'm just wondering, what guidance would you suggest to give where there's no objection? And in my mind, at least from the opening, I wouldn't have, just sitting there, I wouldn't have thought, oh, well, they're contesting identity, or identity is an issue, or I just wouldn't have, I'm wondering, how do we provide that guidance?
I think like any evidentiary or constitutional issue that arises in a trial is that we cannot tell the district court that they need to absolutely take action if an objection is not raised. Right? It's not the purview of the district court to overcome whatever strategic decisions, maybe it was a strategic decision, we don't know, that defense counsel makes in a case. Instead, the mechanism for dealing with a circumstance like this is exactly what we're doing here, which is that it gets to be raised on appeal. If there was an objection, there's a lower standard. But because there was no objection in this case, Antonio is subject to the higher standard of plain error. But if there was an objection during that, then there does need to be, I think,
Yeah, and I'm just wondering if there's not, to avoid having to do these trials over and over, because this stuff happens all the time.
I agree, Your Honor. I just don't know that there's something any of us can do or the courts can do if there's not an objection at trial, right? That's why we have plain error review. For those circumstances where counsel does not object, but there was some type of fundamental error. I think also what's the final portion to focus on for my argument is that these post-Perry, the way the federal courts have applied, Perry does still indicate that there are due process protections for coercive in-court identifications. In fact, Thomas, which is the case cited by Justice Vigil in the denial of cert, in a case does state that improper conduct of a prosecutor could implicate due process, right? And that just wasn't the issue in Thomas and wasn't the issue in Martinez. And in the other cases that we cite in our brief, where the federal courts of appeals have said that where Perry means we no longer apply Manson, again, we're not dealing with prosecutorial questioning or some type of state action. It's all about a challenge to the environmental factor. So I would agree with the state that the court would be correct in saying that a challenge to the general reliability of eyewitness identifications or a challenge to environmental factors outside of the control of the state is not subject to the Manson framework under federal law. But it still appears clear to me that Perry did not overrule nearly 50 years of decisions of the federal courts of appeals that say when a prosecutor engages in coercive or unnecessarily suggestive in-court identification techniques, that we have to, on appeal, apply the Manson framework to find if there was additional reliability to overcome the suggestiveness. We say our position is that the Court of Appeals was correct in this case, that there was not sufficient indicia of reliability to overcome the overt suggestiveness of the identifications in this case. Identification was an issue, and no effort by defense counsel engaging in the procedural safeguards that are present in trials could overcome such an identification as the one that was in this case. So we do ask that the Court of Appeals be affirmed, and if the court has no further questions, I will yield the remainder of my time.
Thank you, Mr. Hart.
Thank you, Your Honors.
So a big portion of Mr. Hart's argument was that these identifications were essentially the only evidence in this case that tended to prove where Antonio was that night or that he participated. I would have to disagree and just point to some of the other evidence in the record. Aside from these identifications, the victim's girlfriend, who was in the car at the time the victim was shot, she testified there were 3 boys. They all looked young. Antonio was the only person, or the third boy was the only person whose face she didn't get a good look at, but she did testify. He was this height, he was medium complected, and he had dreadlocks in his hair. And we now know, based on investigation after the shooting and pictures that were taken of Antonio by detectives, that lined up with the description of Antonio. So that's one factor. Another is testimony from detectives that they actually got tips from the community that Antonio was a person who was involved in this shooting and that he was involved along with 2 other boys. And when they looked into these 2 other boys, they were able to determine that Antonio was a known associate of these 2 boys. There was also other testimony from the victim's girlfriend that she, after the fact, saw Antonio's pages on social media and was able to identify a picture of him holding one of the exact same guns that was used in the robbery. And she could see through social media that he was connected with one of the other boys that she knew for sure had participated. So the idea that these witnesses who placed Antonio at the park were provided the only evidence that he participated, it's not really accurate.
Can you help me, because Mr. Hart makes a compelling case, and I am concerned about this. So is that a plain error analysis, what you just described, or is it a question of at what point is his client's due process rights triggered? And you cite this Domina out of the Ninth Circuit, because it seems to me, I think they're arguing in every circumstance in which there's some kind of identification witness, it's going to trigger this due process. Or is it only when that witness says, not only did I place him at the park, but he said something about a drug trade or a robbery. At that point, when is it triggered? Or what you're talking about, does that just go to plain error?
I would say it's triggered when it's very clear that identity as a participant in the crime, when that is the crux of the identification testimony that's being given, and it's fully at issue. But here, and Mr. Hart mentioned, there was testimony about conversations, intent to do a robbery. None of those conversations happened with Antonio. That testimony was about a totally different person. There's no testimony that Antonio gave any indication before this happened that he intended to participate or that he even knew. And so that goes back to the fact that the defense relied pretty heavily on, he was quiet on the way to the park, so we know from that he had no intent to do a robbery or even knowledge that it would happen. He was freaked out after the fact. Again, we know he didn't intend to participate. And there were some other things the defense relied on. They relied on his demeanor after the fact, his silence on the way to the park. They also relied on the witness's account of how long Antonio was gone from the car. And they said that there was this other witness who said she saw 2 boys hanging around the park for 30 minutes, and then they went and did the robbery. And so the defense said, we know from these witnesses, EM and YC, that Antonio was only gone from the car for at most 10 minutes. And that's how we know that he wasn't one of the people. So they relied on that aspect of the witness's testimony. They also relied very heavily on the fact that after the robbery, Antonio was begging for a ride home. And They said from that, we know that he just wanted nothing to do with this. They also relied on the fact that based on the testimony, these kids never saw Antonio again in a social sense. They never hung out with him again. And the defense used that to establish that he was so horrified by what happened that he wanted nothing to do with these kids. So none of the testimony from these three witnesses went in any sense to Antonio aiding or abetting. All of it actually tended to support the defense's theory of the case, that he did not see this coming, he did not plan to participate, and he was just horrified. None of it, not a single line went to, oh, well, he said he was going to do this, or he said he was really happy about it afterwards. So Mr. Hart argued that the Court of Appeals did discuss reliability under Manson, and I would just point out that the only thing the court said was these children had brief interactions with Antonio, and that was more in the court's plain error analysis. There was no dedicated reliability analysis. And the court's discussion of other witnesses not being able to identify Antonio, that under Manson, that doesn't go to any of the 5 reliability factors, so I would not characterize that as a discussion of reliability. So in this case, Manson federal due process protections were not triggered because identity was not at issue. Even if it was at issue, there's no plain error. And the Court of Appeals analysis under Manson, it has to be reversed because even if the identifications were suggestive, they were reliable. So the state would ask this court to reverse the Court of Appeals. Thank you.
Thank you, counsel. At least from my perspective, you both did a very nice job today, which we appreciate. The case will be deemed submitted, and we will get you an answer when time permits. Thank you very much.